Recording in progress.
Okay, good afternoon. Welcome to the Thurston County Board of County Commissioners appeal hearing proceeding for this Wednesday, May 20th, 2026. It is 1:33 p.m. My name is Ty Mentzer, Chair of the Board. Commissioner Wayne Fournier, Vice Chair, I should say, is online. To my right, Commissioner Carolina Mejia, and to my left, Commissioner Rachel Grant and Commissioner Emily Klaus. The meeting is live streamed to the Thurston County YouTube channel, and public written comment can be received before the meeting and distributed to the board. And the first item on the afternoon's agenda is the appeal hearing of a hearing examiner's decision, Convergent BESS. It's a quasi-judicial hearing, so I will turn to that matter and the kind of preliminary comments that we need to go through. My name is Ty Mentzer. I will be presiding over today's appeal as Chair of the Board of County Commissioners. Here with me, as I've already gone through the commissioners, all five are present. Today's date is Wednesday, May 20th, 2026, and it is 1:34 p.m. The Thurston County Board of County Commissioners is now on record in an appeal of the hearing examiner's decision on reconsideration dated March 9th, 2026. The appeal was filed on March 19th, 2026 by Brian Haight and Tamara Haight. This appeal pertains to the hearing examiner's approval of a special use permit to construct a 5.4 megawatt battery energy storage system at 7505 183rd Avenue Southwest, Rochester, Washington. The facility would include 2 transformers and 2 power conversion systems and would have a development footprint of approximately 16,000 square feet. The applicant is Convergent Energy and Power. The proposed facility is located on portions of property zoned Rural Commercial Center. The completed facility would be owned by the applicant but operated by Puget Sound Energy under a lease agreement. The expected lifespan of the facility is 20 years. The hearing examiner originally denied the special use permit on November 10th, 2025. However, on November 20th, 2025, the applicant filed for reconsideration, a motion for reconsideration, and it was granted the special use after submitting additional evidence. The hearing examiner's approval includes 25 enumerated conditions and is dated March 9th, 2026. The applicants timely appealed the hearing examiner's decision, and this matter is now properly before the Board of County Commissioners. The appellants are seeking full reversal of the examiner's decision on reconsideration and a denial of the special use permit. This is a closed record appeal, meaning the board's review of facts is limited to evidence presented to the examiner. The board reviews questions of law de novo, engaging in the same inquiry as the hearing examiner. The issue before the board today is whether the hearing examiner erred in granting special use for the battery storage facility. As a reminder, the board is acting within its quasi-judicial capacity, which is separate and distinct from its legislative function. Our decision will be based upon law and facts and not on any individual's policy or political objective. Appearance of fairness declarations now is the next piece of our process. In quasi-judicial appeals, the board is subject to the appearance of fairness doctrine codified in RCW Chapter 4236. Under this doctrine, board members are not authorized to have ex parte communications with the parties after an appeal has been filed with the board. However, if there have been ex parte communications since the appeal was filed, or communication or relationships with any of the parties that may appear to impact their impartiality, then the substance of that communication or relationship needs to be disclosed. In addition, each board member must be able to impartially judge this case on the facts contained in the record and the applicable law. At this time, I will ask each of the other commissioners to make a declaration for the record. And we're going to go one by one. Commissioner Klaus, you have that handy?
Yes, I do. Since the appeal was filed on March 19th, 2026, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge the case on the facts in the record and applicable law.
Commissioner Grant?
Since the appeal was filed on March 19th, 2026, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Commissioner Mejia?
Since the appeal was filed on March 19th, 2026, I, Carolina Mejia, have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Commissioner Fournier?
I, Commissioner Wayne Fournier, since the date of, March 19th, 2026, when this appeal was filed, I have had no ex parte communications with any parties involved with this appeal, and I can sit and judge this fairly as applicable law.
And since the appeal was filed on March 19, 2026, I have not had any ex parte communications with any of the parties of this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law. Do any of the parties have objections or challenges for any board member to decide this case?
The applicant does not.
Okay. Hearing none, we'll go to the next piece. This is an overview of the oral argument section of the proceeding. The appellant and the applicant each have the opportunity to present 15 minutes of oral argument. Oral argument may not present new information or evidence and must be limited to the evidence in the record and the specific issues raised in the appellant's appeal. The appellants may reserve a portion of its 15 minutes for a rebuttal argument after applicant's 15 minutes. I understand county departments will not be presenting oral argument, but are available to answer questions from the board, if any. The board, if it has any questions, will ask them of the parties during or after argument. And I'll do my best not to count that time against the portion that's oral argument prepared by the parties. Do any of the parties have questions before we begin oral argument? Okay. So first up, we have the appellant with 15 minutes to present. We'll have a timer on the screen and the clerk will keep track of that. Appellant may come forward.
Good afternoon. Can everybody hear me okay?
Yes.
Okay. So I just wanted to start off just to say that, what we're here to discuss today isn't bus facilities in general. It is this specific bus facility that's been proposed on this specific site with this specific company and the information that they have given as far as being able to be approved for this project. And I just wanted to briefly just go over a few of the areas that we found that this thing should basically be denied or remanded for reconsideration on. The first one is that the determination of use classification for this whole project, there's no evidence in the record that it was ever formally made with an appealable decision by the director of the planning committee. Thurston County Code 20.07060 says there needs to be a formal determination made that this would be considered a power generating and transmission facility. And we can't find any evidence that that was made. We brought it up in the hearings, and county planning staff, Ms. Teeple, said that it was in Exhibit N. Exhibit N does not show that determination. Exhibit N is a determination that this was not going to be classified as a public facility. It says nothing about determining that it would be considered major power transmission and generating facility. Therefore, this entire hearing process has been executed under an assumption of what the use class is, and it's a clear error of procedure. The second thing I would want to call your attention to is that the proposal is not consistent with the Thurston County Comprehensive Plan. And that's specifically because it doesn't serve an identified rural community, it serves the entire grid. The comprehensive plan clearly states that RCC land use must be dependent on a rural setting, and that the use is not dependent on a rural location if it serves a larger than rural market. Serving the entire grid is a far larger than rural market, and so this use should be denied. The next one I would like to call your attention to is Thurston County Code 24.54040, paragraph 3 in special use. It says no application for special use should be approved unless a specific finding is made that it is appropriate for the location. There is ample evidence in the record that the proposed use could result in substantial adverse effects on the adjacent properties and to the public health, safety, and welfare. Therefore, per Thurston County Code 24.54040-3A, for a number of reasons, the permit should be denied. Further, in Thurston County Code 24.54043B, It says that the use will not impose an undue burden on any services in the area. The West Thurston Regional Fire Association clearly stated in the record that an event occurring at this facility would result in an undue burden being placed on the community fire and emergency response. Therefore, per TCC, the permit should be denied. Thurston County Code 20.54.070-20B requires the need for a particular location to be demonstrated, including a full accounting of alternative locations and sites. No full accounting was ever given to demonstrate why this particular site was needed and is not merely more convenient or more profitable for the applicants. No alternative properties were presented in order to determine if they presented less adverse effects and burdens to the community. Therefore, this permit should be denied. The hearing examiner came to these same conclusions in the original denial. Specifically, the examiner concluded that it was not appropriate to approve the permit without an emergency response plan, and that given the fire chief's ongoing objection, it's unclear if a plan could be developed that addresses the issues of concern. In requesting a reconsideration hearing, the applicant stated that an emergency response plan had already been submitted to the fire chief in 2024. One of the main reasons the reconsideration hearing was held was to review the emergency response plan. The applicant did not submit a complete emergency response plan to the record, but a very rough draft that was not site-specific. Many pieces of information were missing, such as the location and contact information for the hazmat teams and their response time, and if they have the equipment needed to monitor for hydrogen fluoride. We raised the fact that Thurston County lacks its own hazmat team and would need which would be needed for air quality monitoring, and that the closest hazmat team was located at Camp Murray and would take at least 2 hours to arrive and start air monitoring. The examiner concluded in the reconsideration hearing, in contradiction to their first conclusions, that the ERP in coordination with the fire chief was not needed prior to special use permit approval. No evidence was cited to justify this change in conclusion. The examiner appears to have based the reversal of her original decision on two main assumptions. The first is that the major energy response plans and hazard mitigation analyses cannot be completed until later in the process. And the second was that the use of LFP, which is lithium iron phosphate, batteries would mitigate all of the hazard concerns that she previously found to be credible grounds for denial. Both of these assumptions are incorrect. We've explained the reasons why in detail, both in our appeal and in evidence that was presented prior to the reconsideration hearing. But to briefly reiterate, the emergency response plans and hazard mitigation analysis not only can be completed at this stage of the process prior to special use permit approval, but they must be in order to fulfill the requirements of obtaining the permit. It's impossible to prove that there are no adverse health effects or no adverse effects on the health, safety, and welfare of the adjacent properties in the community without them. Since this is not a public facility and the determination was made that this was not a public facility, a special use permit cannot be granted without such proof. An example of this being completed at a far earlier stage in the planning process has been submitted to Thurston County for the best proposal in Bucota. The applicant's attorney even stated in their response to our appeal that the reason they aren't supplying the plans at this time is because the county isn't requiring them. Both the applicant and the examiner have stated that the project will not be built if the fire marshal does not approve their emergency response plan, hazard mitigation analysis, and additional required fire protection documents. However, the time of a fire marshal review is prior to commissioning and energization. The project's already been constructed at that point. The hazards are already present. There would be no emergency response plan in place yet, and no ability to stop things at that point. For the second one with the lithium iron phosphate batteries, LFP batteries do not reduce fires, nor do they reduce toxic off-gassing. All 5 of Convergence fires have used LFP batteries that were UL tested and were designed per NFPA 855. What actually prevented harms to people was more appropriate siting and industrial zoning with appropriate buffer zones over 300 feet from the nearest residences. I think at this point, we'd like to reserve the rest of the time for rebuttal.
7:15. And now the applicant will have 15 minutes for a response.
Good afternoon, Commissioners. Appreciate the opportunity this afternoon to speak with you all. I'm Ruben Schutz, and I represent Convergent, the applicant. With me here today is Jerry Leone with Convergent. I'm going to hit on some of the points that were raised, but first, I think what I'd like to start with is kind of a note on the process that occurred below with the hearing examiner. Our position obviously is that the hearing examiner's decision should be upheld, and that's because it is based on a substantial record. We're talking about multiple technical reports on groundwater, on traffic, on noise, on geology, fire risk, et cetera. The county staff reviewed in detail and recommended approval. That's the health department, that's the fire marshal, et cetera. And this was not, sometimes you get a record that looks a little rushed down below. That's not what happened here. Obviously, you guys brought it up, on the introductory comments. There was a hearing, a first hearing, and the examiner had questions. This was the opposite of a rubber stamp. The examiner had existing questions and initially denied. And at the second hearing, she came with all those questions and asked them pointedly. And then, we had a full hearing, and they were answered in a way that she felt comfortable with moving forward. And then she took 60 days, more time than by code, because she knew it was going to be an important and complex decision. And then she issued this 45-page decision with a ton of conditions attached. So this is not a rubber stamp. This was not a sort of, quick process. This was a complex process. More than that usually occurs. One other thing I want to bring up initially, so I don't forget, and that's the SEPA aspect to it, because there was a formal determination of SEPA here, right, in the MDNS, in which it determined that there was no significant adverse impacts that weren't mitigated. And no appeals were filed of that, right? So those are facts that are established for your review. That county process is important in another way, and that's sort of where everybody fits, right? The hearing examiner has the duty to review the entire record, listen to evidence, weigh credibility, and determine the truth, and that's what she did here. And again, a lengthy process, 2 hearings, lots of testimony, a ton of exhibits, as you can see, that are attached to her decision. And then, she puts out this lengthy decision with a lot of conditions. And in your role, you know it well, because you brought it up initially, but I think it's important to reiterate, it's much more limited. This is an appellate process. Here are the specific challenges by the appellants. When it was only 15 minutes of argument, there's no testimony, no questioning witnesses. That happened down below, and that record is set. Moving on, oh man, time flies. The rural character, I just want to touch on that real quick. This is a pretty big site. I think it's 11 acres. This site, by my math, is about, and you could look at, do the math yourself by the square footage, but it's about 3% of this site is this facility. It's got setbacks that are 10 times what is required under the code. It's super low profile. It's not even as high as regular buildings. It's it's like containers, like shipping containers, right? So it's low, it's fenced off, and it's blocked by buildings. The evidence in the record shows you wouldn't even see it as you're driving by once the planting mitigation grows up. There's no traffic. Noise meets the rural standards. There's just far less impact in this area than other allowed uses. And the examiner found that. There's findings in the record for that, and she cites the evidence for that as well. The selection process was raised by the appellants, and so I want to touch on that. They say the record doesn't support this location. The record explains that this was in response to a bid by Puget Sound Energy, right? A need by Puget Sound Energy. And then they looked at 150 plus sites first. They're looking at the zoning, they're looking at the size, they're looking at the location, the necessary facilities, availability, critical areas. And through that process, and this is all on the record, they narrowed it down to 5 locations, and then based on several criteria, including critical areas and including the fact that there's a substation directly across the street, which is important to PSC, they chose this location. So this was a long process. It was an arduous process to determine this location. It wasn't, pointing a finger at a map. And then PSC approved it, which shows that PSC thinks this is the right location for what they need. They raised the issue of that this doesn't serve the local area. And I would just direct your attention back to the hearing examiner's findings and thoughts on that. Again, approved by PSC for one thing, but the hearing examiner, determined that, directly across the street from the substation, directly connected to the substation, all benefits. And essentially, the examiner said, okay, this is a part of a grid system, and grid systems are a bit different, right? Whether it's power, water, cable, or gas, if it's part of the larger grid that serves that area, then it is serving the area. But perhaps more importantly, if you take their argument it's not even logical extreme, it's just their argument. Their argument is basically that no public utilities would be allowed in this area because they are all tied to the grid and serve a larger area, essentially by definition. And the code says that it is allowed. And the law says that you can't deny an allowed use allowed under the code, even if you determine that it's inconsistent with the comp plan. Between those two, the code rules out. Time flies, so I'm going to move kind of through a couple quickly. I got a little lost on that where I was. The point I want to make for the local services, the law can't interpret the comp plan so as to exclude a use that the zoning allows. That's the bottom line. And by their argument, major energy facilities, which are allowed by code with an SUP, would never be allowed, and that can't happen. Groundwater was raised in their appeal. Again, the MDNS, which shows there was no adverse impacts to groundwater, was not appealed, and so that's final. There was a geotech study that was done, evaluated groundwater protection, and shows that it meets or exceeds standards. But more importantly, what the examiner found was that this best use is less harmful than other allowed uses in the aquifer area, right? Including battery, manufacturing and other uses with batteries that are far more labor intensive and less protected. I mean, here, in contrast, what you have is these batteries, right? And they're in a metal cabinet, and then that's set on concrete pads. And unlike battery manufacturing or some other use that is allowed over this aquifer, there's no waste that's generated here. It's contained on that pad. And so the examiner rightly found that, okay, what is this? What are the allowed uses in the CARA? This is less intense than many other allowed uses there with regard to groundwater impacts. Fire risk was obviously a big deal at the hearing. It's come up on the appeal. And we touched on this in our brief, but a lot of the testimony and concern was based on incidents that you can pull up by doing a Google search, but they're not applicable here. A lot of them were much, much larger, 100 times larger, like for the Moss facility. Old rules were applied, old standards, and different technology that has advanced, and that's really important. They're just not applicable and not relevant, and that's where a lot of the concern and a lot of testimony came from. But an important point that I don't want to lose sight of here is that project permit action review, you have to, the hearing examiner, and now you are reviewing that decision, you have to apply adopted codes. You don't make up codes as you go, right? And in this case, there's determined and specific codes and standards that apply. They're national, they're state, they're local, and they're all required here. And the examiner took pains to list them out and talk about the emergency operation plan, the fire safety compliance plan. You know, both of those require collaboration with the fire district. Training is required. Licensed safety engineers, you know, do this. They have to meet all standards. Hazard mitigation analysis, decommissioning plan, periodic safety inspection. I don't want to go into any of those right now because time is limited, but they're all described in detail in the examiner's decision about when they would be required. And there's no operation of this facility. There's no building permit for the most part until these are signed off by the fire marshal at that stage.
Can you stop the clock, Madam Clerk? Can I ask you a question before you
Yeah.
leave the fire question? The appellant, can I get my terminology right? The appellant made reference to Thurston County Code about no undue burden on any services. And then we have evidence from the fire authority or the fire district that it would be an undue burden. My question for you is that code apply? Is that input from West Thurston Fire not credible to you? Is it somehow counterbalanced by other studies and things? What's your response to that piece before you move on?
Yeah, I appreciate that question. I guess two things. I'd answer that two ways. The first is, I mean, it is a requirement. It's part of the special use permit criteria. The examiner found that it did not create an undue burden after hearing from the fire district twice at 2 hearings and multiple written comments. And the reason why is because, you know, at the end of the day, you know, well, let me take a step back. So the fire district said we don't have the capacity, but there wasn't any actual evidence cited, and the examiner found that. The applicant proposed impact fees if necessary. The code allows for impact fees. If more equipment is needed, then impact fees can be used. And that's a condition that she added specifically for that purpose. There was testimony about, you know, how personnel would be used and the best available science for best fires when they do occur is that they're allowed to burn out, because the spraying of water does not assist and can cause groundwater issues. So over time, people have realized that the best way to deal with it is to essentially create a perimeter and watch and so forth. And so the testimony from the applicant was, here's what happens when fires occur. Here's what the fire district, you know, we're going to be training the fire district, and here's what the fire district would be doing. And from that, the examiner determined that it was not an undue burden on the fire district. And the fire district did not rebut that testimony and did not give her evidence to change her opinion on that. And that was after the second hearing when she had questions on this and they were answered. So I know that's probably not the best answer. I feel a little jumbled in the way that I'm saying it. I would direct you back to the hearing examiner's findings on that fact, because I think that she does a good job of explaining why it's not. If they need extra equipment, then you can use impact fees. If they need extra, well, they didn't say they need extra people. In fact, they didn't provide any evidence as to how they would be burdened, just that they would. But that gets to the second part that I think is important. And that's that throughout this process, the fire district has said, we don't want it. Not, here's what we need. Not, here's what would make it better. Not, here's some conditions that should be added. Just straight no, right? A emergency response plan was provided. They didn't provide any comment till the eve of the hearing, in which they put in a letter, and that's what caused, you know, the reconsideration largely. But, you know, can you imagine any other, you know, county agency like not engaging, not providing thoughts on what would make this better, but rather just no?
Thank you. I'm going to let Commissioner Mejia ask a question.
Yeah, I do have other questions. I'll wait to the end, but I do want to do a follow-up to this because we're on the topic. Because you would need that collaboration from the West Thurston Regional Fire Authority, you know. So how would you get to an operational agreement from them if there is a letter, you know, and they are saying no at this point?
Well, I think when you get, they've said no at this point because they've said we don't want the project. But if the project as approved by the hearing examiner moves forward, then there is a list of things that have to be done. And that includes collaboration with the fire authority, right? But at that point, the project moves forward, and our expectation is that they would act as a responsible fire district and engage in good faith to collaborate on what they need, what works for them, et cetera, et cetera. So I don't expect that the project is approved and moved forward and the fire district crosses its arms and says, we are not engaging. I would think that would be a very odd position for them to take. The different operation plans require training, collaboration, all sorts of things that is a cooperative process. And at the hearing, the Convergent testified about how this generally works. And it's usually a really good collaborative give and take process with the local fire authority. That's the way. They were very surprised that this one was not engaging at all.
Can I do a follow-up? Thank you. Thank you. So as you're going through the process, if future fire review, right, that is a piece that you need, and you've touched a little bit on it, but you haven't received that engagement from the fire department right now. But if that completely changes the operational assumptions that you currently have compared to what it comes out later on, would additional land use review be required?
No, I don't believe so. Let me make sure I understand your question. In the process of collaborating on these, like they say, the emergency response plan with the fire authority, if they said we need additional personal protection equipment, or I guess I'm a little confused on what you would kind of see as that triggering that. I mean, the basic answer is there would be no more land use review approval. The process would be complying with the conditions that the hearing examiner has laid out. And the hearing examiner has laid out those conditions, beyond what's required under the International Fire Code and the other safety codes. So what she has laid out as those conditions, that's what would be met per final decision. I mean, does that make sense? I'm happy, I may be answering the question incorrectly, and I don't want that to be the case. So please follow up if you have something that.
I'm going to let you proceed through your argument, and we'll get and stay put, because commissioners may have questions before we let you go. So go ahead, Madam Clerk.
All right, so we talked a lot about the fire authority, and I guess I just kind of want to reiterate on that. We have to collaborate with the fire authority, but the fire authority is not, they don't have the review authority and the approval authority for compliance with fire codes. That's not what they do. That's the fire marshal. Ultimately, what's required is, does this project meet the national, international, local, state codes with regard to fire safety, right? That's the project that, that has to be met. That's the objective. And ultimately, the fire authority has no say in that. That's the fire marshal, and that's because the fire marshal is the expert on that issue. So I'm going to take a step back. A couple things that were raised was, okay, the timing of the plans. Why not now? Why weren't they in front of the examiner, right? First, a lot of it is based on what equipment is chosen. Like the 4650 safety standards, that's based on the type of equipment. And that equipment has not been chosen yet. So that has to happen once, this moves forward a little bit more and the equipment is chosen, and then that review will be done, or that information will be available. And standards can change too. You want to be reviewed under the most current standards, and therefore it happens later. And most importantly, and this is what the examiner said, the examiner is not the expert. The examiner is not the expert with regard to compliance with international fire codes and safety standards. That's the fire marshal. It's just like with, say, structural engineering. You would have that reviewed by experts once you get into the details. And so she made that clear. That's why she's not requiring it this time. She's not the right reviewer. But she did require what has to be reviewed, and it is extensive. And what she required meets all international, national, state, and local standards for safety and for fire safety and equipment standards. I see I got about 2 minutes. The isolation zone came up in their appeal, so I just want to touch on that. The hearing examiner found, based on the record, that there's no evidence for a specific zone. The cited guidance that they point to, the recommended 330 feet, that's the guidance that EPA applies across the board to say, EPA says one size doesn't fit all under that guidance. And it says for facilities like the Moss Landing facility, which is more than 100 times larger, with much worse technology and lower safety standards, you would apply the 330 feet. And then they say that the same 330 feet should apply here. The examiner said there's a gap in information. I don't see any standards here. I see this guidance from EPA, and the fact that they apply it across the board and that they say that you need to look at specific facilities, I don't have anything to go off. So here's what I'd like to do. The hearing examiner said required a specific isolation zone based on site and equipment testing that is used and applied to this facility. So essentially she's saying there will be one, it'll be in the plans. You're gonna base it on the actual technology that you're using, the equipment that you're using for this site. That makes sense, and that was how she dealt with that issue. But I do want to reiterate that the data in the record, the only data in the record shows that fires from these kind of facilities are like other commercial fires. That's what the studies of multiple fires across the board have shown, that these fires are like other commercial fires. Let's see. The major energy facility, you can look at Exhibit N. I'm not going to pull up all the documents. That was essentially, the question is, did the county determine that it was a major energy facility that's subject to a SUP? Yes. And they said, well, there was never an appealable decision. Well, they're appealing it now. I mean, it was made and they're appealing it now. I know my time's up, so I'll stop talking.
Thank you so much. Are there questions for the applicant from commissioners? Commissioner Mejia.
Yes, I do. Thank you. Thank you so much. I'm going to go back to the alternative sites piece.
Sure.
And so, in the record, it's mentioned the approximately 150 parcels that PSC went through, and that it got reduced to approximately 5, and you explained a little bit on how that location was chosen. But there really isn't that full accounting on the alternative locations. So I'm guessing, like, where is that record of the full accounting, besides it just being, generalized summaries on it?
So there is a exhibit in the record from Convergent talking about what they did. There's also testimony in the record regarding that. But I think the question would come down to what is required under the code. When you're talking about 150 sites, are you supposed to have a dossier on each site, with drawings and so forth? That wouldn't make any sense. It would be overly burdensome, unduly burdensome. So county staff in their review are charged with, making that determination. And then the examiner after that, did you just pick this site willy-nilly and say, I want to be there? Or did you look at other ones and determine that this one made the most sense under the circumstances? And then show your math, right? And so they're saying, well, you didn't show enough math. But county staff determined that this was sufficient for them to determine that this was not a first choice, that people looked and determined that this made the most sense after looking at lots of other locations. The hearing examiner, after 2 hearings and lots of testimony, determined the same. So, the deference to their expertise with regard to compliance with code shows that this was met. The neighbors want more, but, what's practical under the circumstances, what's reasonable, that's what should be applied, and, ultimately, staff and the hearing examiner are tasked with making that determination, and they did.
So you believe that the full accounting of alternative locations and sites has been met?
Yes. County staff determined that, the hearing examiner determined that based on the record and testimony.
Thank you. I wanted to touch on another point that got brought forward in terms of the one second. You touched on it towards the end a little bit, and I kind of would hope you would gonna expand because it was actually the first issue that the appellant brought in their testimony today, which is in regards to the classification under the county code. And so, what, in your opinion, is kind of the precise legal basis for classifying this facility as a major energy transmission and generating facility under the Thurston County Code? Kind of like what was stated, right? It was reviewed as that kind of piece on the code. But, the appellant in their brief says, doesn't fit that because the BAS stores energy, shifts energy, redistributes energy, but does not traditionally generate electricity. And even in the county's staff report, they mentioned that those specific regulations for BAS do not currently exist within the code. And so kind of based on that, what do you believe is kind of the legal basis for fitting it under that specific code?
I think the answer to that is looking at, how this works at the county level, with the staff level, when they get an application. They have to interpret their code, that's their job. And oftentimes there's uses that don't cleanly fit under the definitions in the development code. And so the staff is tasked with looking at a use that may not fit perfectly under the definition and determining, based on the definitions, based on the use, et cetera, what is it best classifies at? They do that every day. Every day applications come in and they have to make a determination, an interpretation of their own code as to where this use fits. And that's what they did here. They looked at all the possible uses and they determined that of them all under the code, this most cleanly fits or most closely fits under this definition, and then proceeded accordingly. That's the normal course for staff, planning staff, and it's part of what they do, it's part of their job. And the hearing examiner agreed with that determination that this most closely fits that definition under the code. So it's, in that process of county staff interpreting their own code and the hearing examiner interpreting the code, both of them are determined to be experts at doing exactly that. That's part of their job. That's what they did here. And I don't think that there's any evidence in the record to show that it more closely fits under any other definition, which is what you would do as staff, to fit it under something else.
Other questions for this? Okay,
Chair.
Yeah.
Commissioner Fournier informed me that he has a question.
perfect. Commissioner Fournier, you're up.
Thank you. The appellant referenced the lack of hazardous materials response capabilities, and I know there's a major lack of those type of capabilities within our system regionally. Is that a concern? Is that a valid concern, or is that something you would say would be worked out in the emergency response plan?
It would be worked out in the emergency response plan, but I mean, ultimately, the evidence in the record, and that this goes to the clean energy report, which is the study of multiple fires, best fires, and determining, essentially what was there toxic gas that was measured, et cetera. I mean, ultimately, that report, I would kind of point you to that, to look at, to say that their determination there was that these fires, while they do occur, they're getting more and more rare, with greater safety standards and greater technology and greater equipment. When they do occur, the type of smoke, gas, and other materials are essentially like other commercial fires, or equivalent. And so the concern is there, but it has to be based off the, current evidence, and then the current safety standards that apply. So I know that Convergent is looking forward to working with the fire authority to, address concerns. And we trust that those concerns will be based off, best management practices, current standards, current evidence, et cetera. What's in the record is the, clean energy report, and that talks about these fires. And so I think that gives the best sort of overview in the record of the concerns that the fire authority may have, and that would be worked out through the response plan.
Thank you.
Okay, at this point, thank you so much. We'll have the appellant back for rebuttal up to 7 minutes and 15 seconds.
Thank you very much.
Thank you.
So the applicant talked about that the record was very extensive and that the examiner had this big record, but her conclusions largely mirrored the applicant's attorney's brief. She didn't go over the entire record that was submitted by the public. The public submitted new evidence for the second hearing that the examiner did not, the examiner's findings and conclusions did not engage with the extensive opposing evidence. In the initial hearing, the examiner found the community testimony to be credible. On reconsideration, however, she dismissed them as just reiterated. Not a single public comment exhibit testimony from the community members was cited in the findings or conclusions. And that evidence conflicted the applicant's information, so that was important for her to look at, and she did not. The applicant brought up that a SEPA was already determined, but it was not complete with accurate information. It failed to disclose that damaged or burnt batteries constitute as hazardous waste. They downplayed fire risk as unlikely despite evidence indicating a higher incident rate, including 5 incidents involving the applicant's own facilities. They did not disclose the types of hazardous materials that are released and gases that are vaporized and particulates during a fire, particularly hydrogen fluoride, which is dangerous to the life and health at low concentrations and is odorless. A substation is not necessary to be directly next door to a BESS. It's just very cost effective. The screening of the site is not adequate and no material changes were made to that plan. This is not a public utility, as the applicant said. This BESS is sited within 300 feet of a residential lot. We submitted evidence that firefighters in Sacramento were injured within 300 feet of fighting a very small vehicle fire. The examiner stated that this 300-foot was a gap in the record, and These fires are not like other fires, like the applicant continues to state. Other fires do not produce hydrogen fluoride gases, which are very, very dangerous to people who are within the immediate vicinity, like our family would be, and the other lot that is also next door. The fire chief stated that there is no fire hydrant. That is his big problem with this site. They don't have the capacity to truck water to a long-duration fire. In Lyme, New York, a convergent fire used up their entire fuel budget. There's no evidence that they were reimbursed for that. It is required as condition number 1 that the ERP should be developed in coordination with the fire chief, not the fire marshal. Brian, go ahead and add your comments.
Sure. One of the comments that was made by the applicant was that we're stating the way we're presenting things is that major energy facilities would never be allowed with a special use permit, and that's just incorrect. That's not what we're saying. We're saying this specific one with the information that has been provided in this specific instance is not suited in the particular site, and that's got to do with a multitude of factors that we've covered in our appeal. One of the big ones is this isn't a public facility. This is a private for-profit facility, and there's no overarching public benefit that would allow it to mitigate some of the risks. And so that being the case, it's a very rare thing to find a major energy generating facility that's not a public facility. This is one of those rare cases, and so it may be that if it's a private facility that gets put into a major energy generator classification, that it may not be allowed to be cited in RCC zoning, which is less than 0.1% of the land in Thurston County and was developed for a very specific purpose. It's the only zoning that has a requirement to be for the benefit of the immediate rural community around it. Farther than that, he discussed isolation zones, said that the EPA was saying that they needed to have various distances and that a 330-foot one would be for something like a Moss Landing fire. Well, that's ludicrous. Moss Landing created an evacuation zone of miles, not 330 feet. 330 feet is the minimum isolation zone recommended by all of the experts that is used by the Fire Chiefs Association for any kind of a lithium-ion battery fire, including just electric vehicle fires, which are much smaller than any of these BESS systems. The groundwater issues being less intense, that's only assuming that there's never a problem with this facility and it operates as intended. If there is a fire, which happens about 2% of the time, it is going to create a plume cloud of basically plasma particles that can be nano-sized that are going to fall out on top of the surface ground in the area. And the surface of the ground in that area is extremely well draining. Things don't hold. The water report on Thurston County record from 1984 says that there is no way to remove chemical contamination from the soils here because it will leach too quickly. I know from experience we can't even fertilize our garden in a normal way because a one rain shower will leach all the fertilizer out, so you have to break it up into small amounts. It will leach into a water table that is only 18 feet deep. Operation and building are two different things. When we're talking about when the fire marshal does his review, doing it prior to operation is a completely different thing than doing it prior to building. I strongly encourage you to ask the fire marshal when his reviews would take place in this thing. Normally, when fire marshal's reviews happen, it's generally just prior to final occupancy, which would be operation or energization, not prior to being constructed. Hazmat concerns, he was addressing that, and they are only discussing, he's talked about the energy power, the Clean Energy Report. Clean Energy Report is an industry association that is biased towards the industry. And the only ones that they wanted to talk about in the record were the 3 that happened in facilities that had setbacks greater than 300 feet. And they also didn't discuss whether they monitored for hydrogen fluoride gases in those cases or not. I know with the most recent convergent fire, hydrogen fluoride gas was not even monitored for, and that's the most toxic of the batch. There was another fire in that report that was listed for a smaller BESS that was located closer than 300 feet to a residence, and they made those people move out of the residence for 3 days until the fire was completely taken care of. That constitutes an undue burden on adjacent properties, in my opinion. I think my time is up.
Time is up. Thank you. Any questions for the appellants. Seeing any, I had a question kind of formulating, but I will take a second to think it through how I want to phrase it. It really relates to this question of, and I don't know how central this is, but it's interesting to me, and it's been brought up by both of you about okay, so if it's one, like the fact that it might be allowed by analogy, let's just assume that in a RCC, you're saying, well, that's a tiny portion of the amount of zoning we have in Thurston County in the aggregate. That's not really relevant if there's the argument made by applicant that if the code has an allowance for that type of use, you can't just say that type of use isn't going to fit in that zone. I mean, I guess I want to hear your response to that, or like a little more directly, your response to that argument that, you know, if you say that an energy facility cannot service a rural, so the comp plan issue, basically. Sure. And I do find some merit in that argument that if an energy facility is just deemed to be serving everyone, then it could never be used. And then you're saying, no, we're not saying that it couldn't ever be an RC, but you kind of are saying that, right? Because if it's listed as a possible use, but you're saying that a requirement is that it serve a broader community than the local rural community that it's attached to, and energy facilities would never meet that. There's kind of an inconsistency there that I can't quite get through. We've been getting some advice from our prosecuting attorney's office about some of these really complex legal issues, and so this is still something I'm wrestling with, and if you had any, not putting you on the spot, but
No,
if you have a direct response to that, I'd like to hear
Yeah,
it.
it's fine. So a lot of it comes down to specifics. I mean, energy generation and transmission is kind of a broad area. It can mean a lot of things. What we think about is big transmission power lines or a power plant, but it could be a solar farm. It could be a pipeline. It could be a lot of things. And there's also a big divide on whether it's a public facility or a private facility. Most cases, it's going to be a public facility, especially on the electricity side of things. Now, you could have a solar farm that was privately owned for profit or something like that might fall into the thing too. But a lot of it is nuance, and part of the problem here is that the BES was not something that was ever even considered when this language was developed. So they didn't know exactly, they weren't thinking about that at all as a possibility. But what is clear in the comprehensive plan is that they took this tiny amount of zoning that was specifically to serve the needs of local communities. And it spells it out that it's generally for things like little stores, little services, things so that the rural community can be served without having to commute into the larger cities to get these services taken care of. But it did make provision for generating and transmission facilities because that might be needed in a local area. There could be growth in the surrounding area, and so now they're running into shortages, reliability concerns. They need to add a new transmission line. Then that line needs to come through there to serve the community in the area. So there was provision there for that to happen. But they are also, with generating and transmission facilities, more so than any of the other possible allowed uses under special use permit, they wanted to take extra precautions and have this extra full accounting of why it needed to be there instead of any other place. Why does it need to be there? They don't ask for that for any of the other uses. And they want to see the full accounting. What were the other alternative sites? Is there any of these other ones that will put less of a burden on the community or create less issues with welfare, health, safety, property values, any of it? We didn't get to see any of the specific properties to see if there were better alternatives in this case. But that is why this one specific use has extra requirements. And also, generally, the vast majority of the time, it's going to end up being a public facility too. And when that happens, they give a little more leeway. They say if it's for the overwhelmingly greater good of an area, then we overlook a couple of things on a public facility in order to have that overwhelming good. But this is not a public facility, and we have that official determination from the county that it's not.
Can I add just a
Yes.
little bit to that?
So with this RCC land, it is one of the only ones that showed that, or that states that it should be to meet the needs of a specific community. And there's just these small, discrete little clusters on some intersections in some of our small towns. There's hardly any of this land. And we need this for our services, our stores, you know, gas stations, whatever we need around our community. If it's all taken up by best facilities, because once you approve one, you're going to have to approve more. If we have these intersections taken up by batteries, we have no place for our services. And that is
Commissioners
the
can,
fear.
you can apply and commissioners can create more zoning, just.
I
meet
know,
the
but
need.
then where do we put our houses then, right? So this was set aside for our services. And, you know, just approving something simply because it is on the use table. Major energy transmission facilities are on the use table for even denser residential areas. So every residential area, I believe, in unincorporated first Thurston County, major energy transmission is on the table for them. So are we going to stick this in dense residential neighborhoods just because it's on the use table? You could apply the same standard there. So, you know, the inverse could be true, that we would have to approve them in places where it's not even less appropriate.
I understand your answer,
Yeah.
thank you.
Thanks.
Any other questions for these folks before okay, thank you so much.
Thank you.
That concludes oral argument, and thank everybody for their input and attention. The board will issue its written decision within a week, based on the timelines we have. So we're gonna move to the next piece of our agenda, which is a closed session. So this is pursuant to RCW 4230-140 sub 2. That portion of a meeting of a quasi judicial body which relates to a quasi judicial matter between the parties, getting to the appeal of the hearing examiner decision. We're estimating 30 minutes, but that may be extended. Board action may follow. It's 2:35. We're going to take 5 minutes actually and start the closed session at 2:40. And we'll go until 3:10 with the potential extensions.